Welcome to our deep dive on the estate planning trap. Is do-it-yourself worth a potential million-dollar risk? In this video, we will explore the essential documents every adult needs, when online templates might be sufficient, and when hiring an estate planning attorney becomes a critical investment. We will also cover tax and probate pitfalls, common mistakes, and a practical roadmap to get your plan signed, funded, and stored. First, let's set the stakes and why this matters now. Health scares often bring urgency into focus. Estate planning is not just for the wealthy or the elderly. It is for every adult who wants their wishes respected and their loved ones protected. If you become incapacitated or pass away without clear, legally valid documents, decisions defer to state default rules, and courts may take control, causing delays, disputes, and unnecessary expense. With that in mind, let's outline what we will cover and how to turn concern into a concrete plan. Here is our roadmap. First, we will identify the 3 core documents everyone needs. Next, we will evaluate do-it-yourself options versus attorney review. Then, we will highlight tax and probate traps that can quietly erode your estate. After that, we will examine common mistakes and their real costs. We will finish with an action plan. Along the way, there will be quick quizzes to help you cement what you learn. Let's begin with the essentials. Every adult needs 3 foundational documents. First, a legally valid will, which states who receives your property, who will manage the estate, and who you nominate as guardian for minor children. Second, a financial power of attorney allows a trusted agent to manage financial and legal affairs if you are unable to do so. Third, healthcare directives specify your medical wishes and empower a healthcare agent, accompanied by HIPAA authorization so your agent can access medical information. Together, these documents prevent uncertainty, reduce court involvement, and keep your plan aligned with your values. As a housekeeping tip, maintain a system for originals and copies, inform your key people where to find them, and update as life changes. Now that we have the essentials, let's consider when DIY might be adequate. A do-it-yourself approach can be a reasonable starting point for very simple situations. A single state of residence, minimal assets, straightforward beneficiaries, and no business ownership or special needs considerations. However, even if you use an online template, you must follow your state's execution requirements exactly, such as proper witnesses and notarization, or the document could be invalid. Finally, plan to have an attorney review your documents before signing. Limited review can still catch critical errors. Next, let's examine when DIY becomes risky. DIY becomes dangerous as complexity and value increase. Higher net worth, real estate holdings, particularly across state lines, business interests, and complex retirement assets introduce planning and tax issues that templates do not address. Non-traditional or unequal distributions, blended family considerations, and special needs beneficiaries require tailored provisions to avoid disputes and preserve benefits. Moreover, states have specific execution requirements. Incorrect witnessing or missing notarization can invalidate a document. In these scenarios, attorney guidance is critical. Now, let's compare online platforms with specialized legal counsel. Online services offer speed and affordability, which can be beneficial for very simple estates or as a temporary solution. However, attorneys provide custom drafting for tax efficiency, probate avoidance, and correct execution under state law. Importantly, an attorney coordinates beneficiary designations and asset titling with the documents so the plan functions in real life, not just on paper. For larger or more complex estates, attorney involvement is an investment that typically prevents greater costs later. With that context, let's quantify common mistakes and their potential price tags. This table illustrates frequent pitfalls and their likely consequences. Improper witnessing or notarization can result in a will being invalid, forcing intestacy rules and probate. An unfunded trust means assets still pass through probate, undermining the plan's purpose. Ambiguous language often invites litigation, which quickly becomes expensive. Failing to name guardians leaves critical decisions to the courts. Lack of tax planning for larger estates can cost substantial sums over time. Property in other states can trigger ancillary probate in each jurisdiction. Finally, outdated beneficiary designations can override your will or trust and send assets to unintended recipients. Now let's map a practical timeline from concern to completion. This timeline runs from the initial trigger, like a health scare, through inventorying assets, clarifying goals, and choosing fiduciaries. It then moves into professional consultation and drafting, followed by proper execution that meets specific state requirements. After signing, the critical funding and retitling steps ensure the trust and beneficiary designations match the plan. Finally, you store originals securely and schedule periodic reviews. Following this sequence helps ensure your plan actually works when needed. Next, we will visualize how professionals and custodians coordinate to avoid gaps. Tax and probate traps often appear in the coordination details. For example, step-up in basis on taxable investments may be lost through improper titling or premature transfers. Retirement accounts require careful beneficiary planning and, if a trust is a beneficiary, special provisions to comply with IRS rules. Transfer on death and payable on death designations must match your plan, or they will override your will or trust. Real estate in multiple states can cause ancillary probate unless addressed through titling strategies or placement in a trust. Finally, a revocable trust that is not funded fails to avoid probate. Keeping an updated asset inventory and aligning titles and beneficiaries is essential. With these risks in mind, let's test your understanding with a quick quiz. Quiz time. Which situation most strongly indicates you should hire an estate planning attorney instead of relying solely on a do-it-yourself template? Option A, single checking account, one beneficiary, single state. Option B, $1.2 million in assets, including 2 rental properties in different states. Option C, no children and 1 small savings account. Option D, you rent, have no car, and 1 charity beneficiary. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is B. Multiple properties in different states and a total asset value above $1 million creates significant complexity. This raises the likelihood of ancillary probate, higher taxes, and coordination issues across jurisdictions. An attorney can provide state-specific drafting, correct execution, and a coordinated approach to titles and beneficiary designations. Now, let's reinforce the core documents with a second quick question. Second quiz. Which set lists the essential documents every adult should have? Option A, will, financial power of attorney, healthcare directives with HIPAA authorization. Option B, will, prenuptial agreement, and LLC operating agreement. Option C, trust only. Option D, life insurance policy only. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is A. A will, financial power of attorney, and healthcare directives with HIPAA authorization form the essential foundation. While trusts, prenuptial agreements, business documents, and insurance can be important, they do not replace the need for these core instruments. Next, before we wrap up, we will provide a brief disclaimer to clarify the scope of this content. This content is for educational purposes only and does not constitute legal advice. Estate planning laws vary by state and are subject to change. Your personal facts and assets may require specific strategies or clauses that are not covered here. Always consult a qualified licensed estate planning attorney in your jurisdiction before making decisions or signing documents. Now let's cement the most important takeaways with a quick visual summary. Here are the key takeaways. First, everyone needs a will, a financial power of attorney, and healthcare directives with HIPAA authorization. Second, a do-it-yourself approach may work as a temporary solution for very simple estates, but plan for an attorney review. Third, for larger estates, real estate holdings, businesses, or multi-state complexities, engage an estate planning attorney. Fourth, ensure your trust is funded and that titles and beneficiary designations align with your documents. Finally, review your plan regularly or at major life events. With these points in mind, let's translate them into next steps you can take this week. To move forward, start by creating a current inventory of assets and debts, including custodians and account numbers. Next, identify your fiduciaries, executor, financial and healthcare agents, potential guardians, and trustees. If your assets approach $1 million or include real estate, schedule a consultation with an estate planning attorney. If you used a template, arrange a legal review before signing to ensure proper execution and state compliance. After signing, fund any trust, update beneficiary designations, and secure your originals. Finally, set a reminder to review your plan within 2 years or at the next significant life event. Before we close, I have a quick creative ask for you. Thank you for watching. If this content helped you think more clearly about your estate plan, please like the video, share it with someone who might benefit, and subscribe for more practical guides. Tell us in the comments. Are you Team DIY, Team Attorney, or Team Hybrid Review? We would love to hear your plan and questions for future episodes.